Ladies and gentlemen, this vlog is potentially so serious that I am just going to get straight to the point. I have called it the Cafcass Safeguarding Letter of Doom, and for very good reason. You simply cannot afford to miss this. Following my two recent publications, The 6 Silver Bullets of Hate and Why the Family Court is So Terrifying, the Blueprint of Hate, I have been inundated with emails and calls. We have hit more than a nerve and have for the first time exposed the broken, inept, incompetent and incomprehensible family court system in a way that has never been done before, and which is resonating with literally thousands of you as you find yourselves trapped in a family court nightmare. Now, in this vlog, I am referring to spurious allegations of abuse, and I am not talking about the real victims of abhorrent domestic abuse and violence, which I see in about 20% of cases, which we all reasonably understand as needing appropriate safeguarding. In my vlogs, I am referring to spiteful, vengeful, emotionally unhinged and irrationally anxious resident parents who are mostly mothers, digging up every unfortunate incident in the history of a relationship and throwing all that mud at their ex in the hope that some of it will stick, and to manipulate the family court and judges from planet stupid to minimise, reduce, restrict or deny child contact. And I believe that thousands of you are on the receiving end of all of that. Now, let me make an analogy. When the non-resident parent throws those spurious allegations of hate, think of that as being the start of a tumour, perhaps small at first, but with every mudslinging allegation and assertion it grows and grows. But when that tumour enters into the family court process itself turns it into a cancerous growth that quickly spreads and spirals out of control. And what I am going to argue today is that the cancer often starts with the Cafcass safeguarding letter, which I am calling the safeguarding letter of doom. Let me explain. But before I do, I simply must run my excellent introduction. I am Philip Kedge, a retired police chief inspector, the director of the Mckenzie Friend UK network, the founder of the national campaign of #LikeNotHate and fearless family court vlogger. In all my vlogs, my views and opinions are entirely my own. Don't forget to like, share, subscribe and hit that notification bell. For those who may not be aware of the safeguarding letter, let me explain it in under 30 seconds. After an application is made to the family court for child arrangements, Cafcass will conduct a safeguarding telephone call individually with each parent. The purpose of that call is to ensure that the children are safe and well, to discuss the disputes between the parents in terms of child contact, and to explore any allegations of domestic abuse. After that call, the Cafcass Family Court Advisor will produce a letter to the court which is shared with both parents. This letter will contain their early recommendations, and it is at this point that the family court nightmare often begins. Ladies and gentlemen, I am going to explain a scenario which I see repeating itself over and over again. Are you sitting comfortably and ready for this? The parents separate. Traditionally, the father leaves the home. The mother then stops contact. The father attends a MIAM, a mediation information assessment meeting, in the hope that by attending mediation, contact can be quickly restored. However, the mother declines mediation, citing domestic abuse. With no other options available, the father submits a child arrangements application. The mother responds with a C1A form full of hate and spurious allegations. Cafcass conduct their safeguarding calls. The father denies the spurious allegations made by the mother and may even put forward some of his own. The Cafcass Family Court Advisor writes their safeguarding letter, sends it to the court with copies to the parents, and boom, in the last paragraph of the letter where it provides recommendations, it states something similar to this. Given the allegations of domestic abuse and harm made, I cannot support direct contact at this time. The court will need to consider Practice Direction 12J and whether a fact-finding hearing is required. That, ladies and gentlemen, is the Cafcass Safeguarding Letter of Doom. And from what I observe, it often appears to be the default position taken by Cafcass Family Court Advisors when allegations of abuse have been made by the resident parent and where contact has already been stopped. However, it is my personal view that this default position is frequently based on total risk aversion with only a superficial assessment of the issues and allegations. When spurious allegations are clearly being made, I see the door on contact simply being slammed shut, case after case after case. The tumour of spurious allegations are now turned into cancer and quickly takes hold. The father who applied to the court naively, believing in justice, fairness, and that the court will apply common sense to reunite him with the children, now faces the prospect of a spiralling out of control family court nightmare. So, let's take a look at what may happen at the first hearing. At the first hearing, the mother, with her all too often sick in the head family lawyer, can now easily manipulate the court. In order to ensure that the court process heads down the long and drawn-out fact-finding pathway, they double down on these spurious assertions, allegations, and sound bites of hate. So, the judges, many from Planet Stupid, when faced with this ongoing onslaught of spurious allegations, will simply put it all in the too difficult basket for that hearing and order the mother to submit a full statement of allegations, a Scott schedule, and the father to submit a statement of his responses to the allegations. So, what about interim contact, whilst all this nonsensical drama and hate unfolds? Well, what fathers tend to be totally unaware of is that the family court judge, when it comes to interim contact orders, has incredibly limited authority and powers. The judge turns to the father, who provides a logical, common sense argument that until they separated 3 months ago, he had raised their happy, well-adjusted children over the last several years. So what exactly is the outrageous and gratuitous harm that the court thinks he is suddenly going to inflict on the children? That means that contact has to be denied. To deny contact is simply outrageous. A very good point, well made, I suggest. Next, the judge turns to the mother's sick in the head family lawyer, who has no professional duty of care to any child. How disgraceful is that? And asks why the father can't have direct contact, even if it could be supervised contact. The sick in the head family lawyer already has this base fully covered and simply refers to the Cafcass Safeguarding Letter of Doom, stating that Cafcass, the family court advisor and expert, has determined that direct contact cannot be recommended whilst fact findings are being considered and issues around domestic abuse determined. The lawyer goes on to state it would be highly unusual for the court to put a child at risk by disregarding the Cafcass safeguarding letter, and strongly hints that doing so may even give rise to an appeal. So, following the exchanges, the impotent, spineless and equally risk-adverse judge simply capitulates and makes an interim order that prohibits any direct contact between the children and the father. And can you believe this? Where the father could actually go to prison if he breaches that order. The next hearing is listed in over 3 months' time. The family court cancer is now spreading uncontrollably, and for the father, there is no family court chemotherapy to turn to in order to stop it. Indeed, it is not uncommon that it may be another 6 months, 9 months, or over a year before he gets to touch, hold, embrace, cuddle his children again, to tell them to their faces that he loves them. What can I say? It's a totally sick system. So broken, so inept, so incompetent, and so utterly incomprehensible. Children being systematically ripped from the loving bonds of their fathers. And where does the cancer start? With the Cafcass safeguarding letter and the risk-adverse, ill-considered, draconian recommendations of no direct contact based on unevident, spurious assertions, allegations and sound bites of abuse and coercive control made by hateful and vengeful resident parents who are mostly mothers. In effect, that safeguarding letter of doom permits mothers to kidnap the children into their care, where the family court cancer can now become even more aggressive. The mother has months and months to weaponise the children against the father, to demonise and push the father out of the children's lives, to make the children anxious and fearful of the father, and to ensure that they become entirely emotionally dependent on themselves as the mother. And of course, the judges from Planet Stupid then fall over themselves to support the all-empowered, loving, caring mothers who simply have to state that they are doing everything they can to promote contact. And let's not forget Cafcass, who now report that child attachment issues with the mother is a legitimate reason why a child may not wish to see the father. So, the cancerous family court system can even become terminal as the end game approaches, when Cafcass and the judges from Planet Stupid now hail the voice of the child. After months of drip-feeding manipulation by the mother, the child now expresses that they don't want to see their father. I have even seen the voice of children as young as 5 years of age being considered as a factor under the child welfare checklist, influencing outcomes based on the balance of probability. How insane is that? So what do we do? It's time to take a stand. It's time to fight back. It is now totally and abundantly clear that we can hold no faith in any meaningful reforms of the family court by the President of the Family Court, Mr. Dressy-Uppy himself. An invisible, totally ineffective leader who has failed to get any grip on the chaotic madness of our family courts. Enough is enough. It is now time to appropriately challenge and change the family court from the inside. And that is exactly where my future focus will now be heading. So watch out for my next series of vlogs where I will be starting to share my ideas and thoughts on how non-resident parents, who are mostly fathers, can take a stand and how we can take back some control of the broken and inept system And in the same way that it is being totally manipulated by mostly mothers and their sick in their head family lawyers, how we can start mirroring that tactic back. It is going to be very, very interesting. Until then, stay strong.